where do you feel like people may go wrong when they're trying to modify or change either decision-making or parenting time? What are common mistakes that you see in your practice?
I think it's truly because
Hi, everyone. Welcome to the Illinois Family Law Insider Podcast. My name is Katie VanDeusen, and I'm the managing partner at Sterling Lawyers. And with me today is Leah Diaz. She's a senior associate at our firm. So thank you, Leah, for joining me today.
of course.
So, Leah, today we are going to delve into post-judgment issues, meaning modifications to custody and placement, what we typically call allocation of parental responsibilities, as well as parenting time. So, just in terms of an introduction, as kids continue to get older, things change. Sometimes parties may find a need to come back in and request to modify or make changes to orders that were originally entered. So, in terms of your legal experience, let's start with some of the basics. What is the biggest difference between modifying custody or allocation of parental responsibilities and parenting time?
Yeah. So custody, I also call it allocation of parental responsibilities, is really dealing with decision-making responsibility for a child or children, specific to education, healthcare, extracurriculars, and sometimes religion, depending on circumstances. When parenting time, you're talking about, okay, physically who has the kids when, and basically who is the child or children going to be with during that specific time. So you can modify both, and both have different standards, and within each there's different standards for different circumstances.
In terms of like changes, so just so that I'm highlighting this, so at any point in time, you could seek a change or to modify allocation of parental responsibilities or that decision making piece and parenting time, correct? So it's never a situation where once you've entered something, it's just forever set in stone, specifically with kids.
Yeah, both of them are modifiable, and that's, kind of different from when it comes to like modifying financial issues. It doesn't really matter how a divorce decree is entered or how the wording is. Both of these issues would be modifiable.
Got it. Okay, that's good to know for sure. At any point in time, you can seek to change those things or come back in and maybe take a look at those things. So, when it comes to modifications, Leah, based on your experience, what would you need to prove, or what is the legal standard for making a change or modifying decision making or that allocation of parental responsibilities we talked about?
Yeah, so depends on timing. Overall, I think like an overarching theme to modify anything really in general when it comes to parenting time or decision making is what's in the best interest of the child or children.
Yep.
But specific to decision making, if it's within 2 years of your parenting agreement being entered, so it's very specific to your allocation judgment being entered, that's important because it technically could be entered before your divorce was finalized. But from when that allocation judgment is entered, if it's before a 2-year time frame, you have to show some form of serious endangerment to the child or children in the circumstances. That's not just physical. It can be like, mental, emotional, any type of endangerment like that. But ultimately, there has to be something serious that's occurring that would allow you to come in and ask to modify that decision making, which overall you would be asking to do that in the best interest of the kids.
Okay.
If it's after that 2-year time frame, just kind of the standard substantial change in circumstances need to occur. So any kind of big change, and then showing that that change that you're requesting is in the best interest of the kids.
And we'll dig into kind of what that substantial change or what rises to the level of a substantial change. But then following up on that, what is the legal standard, or what do you look for when modifying parenting time?
Yeah, again, best interest of the kids is always going to be a cornerstone. So if you want to modify parenting time, you have to show what you're wanting to modify it to is in their best interest. And then substantial change in circumstances. If you don't have a substantial change in circumstances or nothing big has occurred, still have to show it's in the best interest of the kids. But there's certain situations where you can come in without showing that substantial change, which are things like you guys are actually operating under some different type of parenting time schedule. What you want to change within your agreement is really small. The modification or the request is somewhat necessary because the court would not have entered the original order had the court known or been aware of this type of circumstance at the time of the entry of it. Or, of course, the catch-all is if the parties are in agreement.
Got it. Okay. So it sounds like for the most part, when it comes to parenting time, best interests, that always applies. And whether or not there's a substantial change that has to occur is really fact specific based on the particular case. And you can sometimes get around it if there are these other things that are met.
Yeah.
Got it. Okay. And then what would you say, in your experience, Leah, would rise to the level of a substantial change when it comes to parenting time?
So I think with parenting time different than financial, it's kind of like an anything goes, any like big change. So things that people don't even think about, something could happen and it would result in a substantial change. But most common are, ability of parents to exercise the schedule that was set for. So if their like work schedules changed or if they moved or, something's preventing them from being able to deal with transportation or anything like that, and it impairs their ability to exercise that parenting time. As kids get older, obviously they change. So what they want or what they need could result in a different type of parenting time schedule. Maybe one parent's really good with helping the kids with homework and one of the kids is really struggling. So maybe that kid should be with the other parent so that they can really help improve grades and make sure that kid's doing better. Poor academic performance can obviously result in some form of a substantial change. If one parent just isn't complying with the parenting plan, that's going to be a substantial change. When it comes to like circumstances or incidences where you want to restrict parenting time, like some big things happen where you are emotionally, mentally, or physically kind of placing your child in some form of serious endangerment, that will obviously rise to some form of substantial change also.
Yeah, and it's interesting because like with parenting time specifically, whether or not, it's a change or a substantial change, like I think that's also so fact dependent and it depends on the judge because like someone may view the homework example that you just described like that may be a minor modification to a judge and that may be enough to come in and change parenting time or what qualifies or is defined as a minor modification versus like a major modification for parenting time, I think is so subjective. So,
Mhm.
I think while I started talking about this as being like what counts as a substantial change, it may just be what counts as a change that you may want to consider coming in and trying to modify parenting time just in general, right? And you flagged it for us like work schedule changes, a relocation, the child's needs change, whether medically, emotionally, academically, like you went into, someone not exercising time. So, like, all of these things should be kind of spurring us as attorneys or even people who are listening. They may want to flag those things as, okay, I should be reaching out to my attorney because I want to make a change to the schedule or I want to talk through that and what that, looks like.
I think it's like a constant battle too with like you want to make sure that you have enough of a substantial change to kind of get you through that first piece to be able to go in and ask to modify. So you want to make sure you're beefing up what you're putting before the court as much as possible, but you also don't want to not jump the gun and make sure that you're not filing things also. So you're really kind of balancing between I know I want to get this on file as quickly as possible, but I also want to make sure we have enough to make sure that the client can come in on that substantial change.
So true. Okay, and then shifting gears, Leah, when it comes to child preferences, I feel like in a lot of cases we hear this from clients. My child or my children want to live with me. They want to spend more time with me. Do courts consider the child's or children's preferences when making these decisions as to whether an order that was previously entered should change or not?
More often than not, when we're dealing with a child preference, you're probably going to have a guardian ad litem appointed in your case, which is an attorney for the kids. So that guardian ad litem is really doing the investigative work outside of court to kind of get a full picture in terms of what's going on. Very rarely do I see judges opining on what the kid wants without a guardian ad litem being appointed when it comes to those types of factors. So really, I think the child's preferences is really only going to be considered if the guardian ad litem finds it relevant. I usually, again, like the guardian ad litem being appointed is really good in those circumstances because sometimes, depending on the age, type of kid, where they're at, sometimes they want to go with the parent who isn't disciplining them, right? Or kind of letting them do what they want to do. So
Yeah.
really the point of this guardian ad litem is to vet through those things and investigate it further. You're only getting the position from your client. So it could be a different picture than what's actually happening. So when it's something like that, a guardian ad litem and a judge aren't going to consider a child's preferences when they're wanting to go with the parent who like isn't disciplining them or isn't gonna, make sure that they're doing the things that they need to do that's kind of in their best interest, right? I've really had that be like a transitional factor or something that really kind of pivots a case in situations that are a little bit more extreme where people are starting to be concerned about the kid, right? Like if something doesn't change for the kid, we're really concerned about what that kid's going to do or how that kid's going to react or feel, right? And the response to that, really when it's something significant like that, do I see some form of a pivot? Or in one of the circumstances that I've had, a parent didn't exercise any parenting time for like the first, I think it was like 9 years of the child's life.
Wow.
And courts obviously want to have parents involved. So when this parent came back and wanted to be involved, we were kind of a little iffy on everything. And then the child was so anti and really talked to the guardian and led him through why she didn't want to have a relationship with this parent. And really, when again it was that extreme, did I find it to be pivotal where the child's preferences were really, really considered. Otherwise, it may be a very, very, very tiny facet of the bigger picture of whether or not the modification will take place.
Yeah, I usually liken it to whenever I'm talking to a client, it's one factor among many, and it is not, in my experience, I don't think it's ever been a deciding factor. It's just been one factor to consider in terms of the overall whole. And I think also it's hard because certain kids, based on age, they may be mature enough to share that feedback. They also may have been coached in terms of their feedback. So it's just really hard. And I also think there's this element to, not putting a child in the middle to decide, right? Like the sheer nature of that factor and putting the child in the middle of these two parents and having to state a preference in general, I think puts a child in a very difficult position unless maybe there's like safety concerns or underlying,
Yeah.
mental and emotional health related issues. But I think it's just really hard to explain that to parents when maybe they're hearing their child express something or say something, but how that translates legally to a case, it's not always like directly transferable, or like it doesn't always directly impact the outcome. And I think that sometimes is hard for parents to hear or for parties to even hear sometimes.
And it doesn't necessarily mean that what the child's saying or what's, going on isn't going to be heard by the court in any capacity, right? Whether it's through the guardian ad litem or through the judge.
Right.
It's just whether or not that's going to be such a determinative factor to allow for the modification. Again, it's really just a factor that can or cannot be considered depending on the circumstances. But it doesn't mean it doesn't get heard,
Yep.
but whether or not it changes things is different.
Exactly. I could not agree more with that 100%. And then, Leah, I'm going to ask you, where do you feel like people may go wrong when they're trying to modify or change either decision making or parenting time? What are common mistakes that you see in your practice?
Feel like I could have like an hour conversation about this, but I also think it's truly because the parenting portion of things, when it comes to like custody and parenting time, there's such a gray area sometimes when it comes to these things that people, sometimes attorneys aren't sure if this is going to be enough or whatever the case may be. So, especially when it comes to people who aren't well versed in the law, of course they're going to feel a little bit more lost when it comes to these things. But truly, I think primarily you jump the gun, you file too soon. And that's really also specific to without having to show a substantial change in circumstances, but you want to do what you guys have been operating under. The statute requires 6 months to show like what you guys have been operating under.
Yep.
Sometimes that's not enough for certain judges. Sometimes they want to see a little bit longer. So I'm really careful with my clients about that 6 month timeline because sometimes I want it to be a little bit longer than that 6 months, depending on where we're filing. So you can jump the gun too soon on some of these things. That's why really consulting with attorney on some of those stuff, especially fact specific things like that, is important. If you and the other parent have spoken and quote unquote agreed to something, and now all of a sudden, especially when it comes to verbal, oh my goodness, verbal, it's not written down, somebody is all of a sudden not in agreement anymore, and now you're in front of the judge is going to be looking to what's on paper. So no relying on verbal agreements at all. At very much so minimum, make sure something's in writing somewhere. Failing to document violations of the current plan. I also always, especially when it comes to people who aren't entirely sure if somebody's going to exercise time or they haven't been reliable in the past, keeping a calendar, whether or not it's going to get used in the future. Just calendar everything so that you have something to fall back on if you do need to come back in court. Worst case scenario, you don't need it, who cares? But at least you're being diligent about keeping those records.
Yep.
And then just doing something on your own, one, without even consulting with the other parent, but two, without also having any type of court order in place, and just doing something on your own.
Definitely. Those are all good things to keep in mind, and like mistakes or pitfalls to try to avoid moving forward. And then, Leah, in terms of, we've been talking today about modifications, changes to a previously entered court order. Can you describe for me the difference between a modification or a change versus maybe an enforcement proceeding for those listening who may not fully understand what the differential is?
Yeah. So the main difference between enforcing and modifying is when you're looking to enforce, you have your court order entered, and somebody, both of you guys or one person in general, is just not complying with that order. When it comes to modification, you're actually looking to change your prior entered order depending on whatever circumstances have changed or where it no longer serves the best interest of the kids. But you can do it hand in hand with each other. There can be, you can't ask to enforce and modify in the same breath depending on the circumstances. But enforcement's really, there's an order entered, and somebody's not complying.
And then kind of delving into some of your experience when it comes to post-judgment cases, I want to ask you, have you ever had a case where maybe a parent moved away, moved out of state, moved distance, and it really kind of impacted or changed their parenting time or the amount of time that they interacted with their child?
Yeah. So if you're given primary time, general rule of thumb pursuant to the statute is if you move outside of a certain area, you have to have permission from the other parent first before doing that. So usually I don't see that often because that's kind of difficult to get granted.
Mhm.
I see it more so when the parent without a lot of parenting time or without a majority of the parenting time moves.
Yep.
I've also seen it in circumstances where parents have 50-50 or close to 50-50, and then somebody moves and that 50-50 doesn't serve anymore. So that often than I would think I would see with like a 50-50 situation, because if you're going to have equal parenting time or close to it, you guys need to be close together. It cause that much disruption for a kid.
Yeah.
So if you then decide to move 30 minutes away, even though you still might be within that radius, it may not serve the child to still be doing that, much back and forth between parents that are 30 plus minutes away from each other. So,
Right.
absolutely.
And it could have an impact on the schedule. If you're moving far away, the child will be in the car more transportation time. That may have an effect on their schooling, depending on how much homework they have or how old they are. So, yeah, it's like these decisions can have long lasting effects or, really alter what was originally entered, based on just that change that could occur, and life happens. So, and then what about, have you ever seen a situation where maybe a parent was continuously, repeatedly violating a parenting plan that was originally entered? And what did the judge do? How did the judge handle that, or what was the outcome there?
I'm actually dealing with that right now, but um,
You're like,
I
TBD.
it's actually insane. But I truly think it first kind of depends on what that violation is.
Yes.
So if it's a situation where like one parent, for example, is kind of primarily responsible for like, like the day to day, keeping up with the like doctor's appointments and things like that. And they're supposed to kind of notify the other parent, for example, and maybe they're not notifying each time or they haven't been doing it religiously, but the other parent has access to be able to see information from the doctor directly. Maybe a judge isn't going to be so mad about that circumstance because, it is a lot on one parent to keep updating the other parent each time when they can do it themselves and see what's going on.
Right.
So something small like that, where it's probably a very big amount of violations that have occurred, the judge may not care as much about something like that. More extreme situations, or even just maybe not only not updating, but there's also a couple other things that the parent isn't doing, right? And complying with, where it gets to the point where the judge is kind of feeling like this person just thinks no rules apply to them and they can continue to do what they want to do as opposed to what's best for their kid and the other parent. I've honestly seen a lot of judges kind of take that more personally, where somebody's not complying with the orders that they entered. So I've seen situations where, parents keep violating and it's resulted in such a negative impact on the kid that they've flipped schedules where, one parent gotten significantly less time with that kid because they're not acting in their best interest anymore. So it can get really extreme if somebody decides that they don't want to comply with the court order.
Yeah, never a good idea to make a judge angry at you in terms of that.
Yeah.
It will not serve you in the long run. And then, final takeaway in terms of our episode today and kind of the substance and what we've talked through, Leah. What is one thing that you wish more clients understood before making that decision to come back in and modify or change decision making or parenting time?
I think that this could change at any point depending on what like my theme is that I'm dealing with for the year, for example. But I feel like this year, particularly, I've seen when they're wanting to come in and modify, it seemed more of like this person's doing this. That's not what we're supposed to do. It's negatively impacting me. What I really wish parents would consider, because really the overarching theme of all of this is what's in the best interest of your kids. So if you're noticing impact on your kids, and it's negatively impacting your kids, that's really what I would kind of hone into when it comes to modifying. So like, even if you think, hey, I want to move because I want to move for a job opportunity, really take a step back. Like, is this a good idea for my kid? And why? Because if you're looking through that lens, the statute's probably going to be closer in your favor than if you're more so thinking what best serves me or what the other person is not doing or is doing.
So true. And just you boiling it down, it really does depend on the child and like the impact on the child, right? Like
Yeah.
that's the focus. And that's really strategically what you need to highlight or hone in on as an attorney. And, if you're going to consider going back, that's what you have to do as a party. So thank you so much, Leah, for joining me. I really appreciate you coming on Illinois Family Law Insider podcast and joining me today to talk through post-judgment modifications of decision making or allocation of parental responsibilities and parenting time. And thank you so much for just sharing with us, Leah, in terms of your experience and what you've seen. It truly is just invaluable to the listeners. So thank you so much.
Of course. Thank you guys.
Because so many post judgment parenting disputes eventually involve a custody evaluation, it's critical to understand what evaluators are really looking for and how parents unintentionally hurt their case. In the next episode, we break it all down step by step. So click here to watch.